What I want to do is I'm going to be summarizing many of the items that are in the report, but I'm not going to restate the whole report and what we have. What I want to do is kind of give you a little bit of a history of this, and then I'll make a recommendation at the end. Let's just start with the Retirement Board. With your authority, there's no question you have a fundamental fiduciary responsibility to pay benefits to members, and that means correct benefits to members. That is a constitutional obligation that you have, and that is something that we strive to do forever. You know, ever since the Ventura case came down, it's almost 20 years now, that this board and many boards have been struggling with the whole idea of what's pensionable, what's not pensionable. There have been lawsuits and litigation. It's been the Attorney's Full Employment Act. And it was primarily because a unanimous Supreme Court ruled in '97 that essentially more than base pay had to be included in pensionable compensation for our members. And frankly, in the last 20 years, we've spent an enormous amount of time together talking about what goes in, what doesn't go in, what counts, what's spiking, what's not spiking. What the media calls spiking is not what the lawyers call spiking. But these issues have been front and center with us for a long, long time. And so I put this slide on here just to remind you that your responsibility is to examine benefits constantly and determine what is the proper compensation to be counted in calculating someone's retirement allowance. We have authority under the 37 Act of Searle to make corrections. In two instances particularly. We have general authority to make corrections anytime. The IRS requires us to correct errors in calculations. You have an overpayment and underpayment policy that talks about what happens if we overpay someone's benefits, what happens if we underpay someone's benefits, what happens if we overcollect or undercollect contributions, and that's posted on the website. Our statute gives us the ability to correct errors that come about in two particular situations, and this is specific statutory authority. One of them is if the member or the employer commits fraud on the system. And the other is, in the same section of the code, the other is that we may correct a retirement allowance for an error if it is shown that the member improperly caused his or her benefit to be increased at the time of retirement. And that's the phrase in the statute, that the member caused his final compensation to be improperly increased or otherwise overstated at the time of retirement. And because it's recognized that our system takes time to get the facts and to understand the situations that occurred at the time of calculating benefits, this is one of the longest statute of limitations that appear in the law. The law gives you 10 years from the time of discovery to make a correction. And that is a legislative statement that it understands that it may take a substantial amount of time for you to discover that the member in this situation caused the compensation to be improperly increased. The legislature, when it passed, you know, PEPRA, of course, and so we now have legacy members and PEPRA members. In this case, the retiree at issue here, Mr. Nowicki, was a retiree at the time PEPRA came in. So he was neither a legacy member nor a PEPRA member affected by AB 340 and AB 197 that enacted these new laws in 2012, effective January of 2013. However, the legislature again gave us tools in 2012 as part of that legislation, that reform legislation, to again look at whether or not members had improperly enhanced their benefit. That new law, the enhancement of benefits, does not apply in this situation to someone who is already retired. But I point it out because it's a legislative acknowledgement that this retirement board has the charge of exercising its judgment in making these calls. You notice, as I said in the memorandum, the statute does not tell us what is a proper or improper. There's no bright line, there's no chalk line that you know you're running downfield and you're either inbounds or outbounds. It's up to you. The legislature has told this board and boards like it that it's up to you to exercise your judgment in deciding what is a proper increase and what is an improper increase under all the circumstances that are presented to you. And you have started to exercise that responsibility over the last year or so, 2 years, I guess. My gosh, has it been 2 years, Karen, that we've been involved in this process probably. This is what we call the look back project. You instructed staff to look back at pre-legacy and pre-PEPRA members, those who had already retired before 2012, and let you know whether they discover any specific instances of unusual end-of-career behavior that would appear to be specific to certain individuals as opposed to an entire class of individuals, and that caused a spike, if you will, small s, spike in retirement benefits because of that behavior. And we've spent an awful lot of time over the last year and a half talking about things like on-call schedules and callback schedules and how they were classified by the county in other districts. And Kurt has put up on the board for you a number of demonstrations where people had no callback, for example, during their entire career, and suddenly in their last year, they've signed up for callback for the entire department, and you see that last bar go through the roof. This examination of this benefit for this individual is part of that look back project that you've commissioned us to carry out. And you have started to adjust allowances for people when it has been shown to your determination, to your satisfaction, that there was an improper increase at retirement and benefits. So here's what we're going to do today. We're evaluating the retirement allowance paid to the former fire chief, Mr. Nowicki, of the Moraga Orinda Fire District. We've done our best to assure him and his spouse, his former spouse, who splits the benefit under a DRO, of due process. We made available our memorandum to him a month ago and all the backup documents. We've invited him to be here and to present as well. We've asked the district to come and speak today. I received word from the district's council that they did not intend to be here today or take any position on this matter. But they received notice as well, since it is, the benefits that they promised and that they're paying for that are at issue here today. And again, I say this is really just a summary. I'm not going to try to repeat everything that's in our materials, but so I ask you to look to the detailed evaluation that's in the memorandum. I will later point out to you 2 or 3 changes that we recommend from our analysis based on some ongoing information that we received. Okay, so let me just lay the table here, just a few basic facts. Mr. Nowicki was the former fire chief of Moraga Orinda Fire District, joined the district in June of '83, became a Cicera member at that time. He was appointed fire chief in July of 2006. He had a 4-year employment contract that would run through 2010, July of 2010. Midway through that contract, Mr. Nowicki retired. He retired effective as of January 30, 2009, at age 50. He had 26 years of credited service It's actually a little more than that. I think when we put it together, he had about 25.5 years and maybe 2 or 3 years. He had 25.5 years, I think, with Cicera. And then he purchased 2 or 3 years of prior public service for a total, I think, probably around 28 years credited service. That's what it comes down to. We've attached the contract, tab 1, so you can see what his contract was. This was his base contract that was supposed to cover his performance and duties and compensation for 4 years. His annual base salary, $173,000. He had vacation leave with 20 hours a month, 240 hours a year. Unlike some other districts and some other participants in the system, under this contract, none of those hours were cashable. They were usable as time off, paid time off, but none of them were cashable or sellable, whatever verb you want. You couldn't sell them back and get cash. He had 80 hours of administrative leave that had to be taken. It could not be accrued, and it could not be taken in cash. About 1.5 years later, Mr. Nowicki and the district entered into an amendment of that contract. Under the amendment to that contract, his base salary was increased to $186,000, another $13,000 a year. He received, and this first amendment, by the way, is tab 3 in the materials, if you can find it. Under this amendment, he was now entitled to cash out vacation leave. He could sell back up to 200 accrued hours that had accrued before, if it accrued before July of 2008. The amendment, however, in the accrual of vacation and the right to sell it back was backdated 7 months to July of 2007. And so for the period of time that previously under his base contract, under his 4-year contract, he did not have the right to sell back any hours, he suddenly, in January of 2008, not only received the right to sell back going forward for earned hours, but to sweep backwards in time and pick up essentially a bunch of hours that could be sold because they were accrued under the contract retroactively and made cashable. And in fact, as soon as the contract was signed on January 16th of 2008, within a couple of weeks, he sold back 200 hours of vacation time. The reason that's important is that this is within the final year of final 12 months of compensation, so that it immediately became pensionable under our policies that were in effect at that time. Up until that point, he did not have the right to sell back those hours, and it would not have counted had he retired during this 1-year period. It would not have counted towards his retirement allowance. The evidence as appears to us and from the records of the district and the records that we have here at Cicera, it is evident that Mr. Nowicki, at that time Chief Nowicki, was an active proponent and participant in this process. We have no indication that any of this arrangement was done in open session, made available to the public. It was done with the district board behind closed doors. And again, as I say, there's nothing in the record that we have seen, the minutes of the meetings of the fire district board, that indicates that the public had any information relating to the change in compensation that was made available to the chief. If you also look at Exhibit 9 to the tab, This is a memorandum from Chief Nowicki in January 8th of 2008, just before the contract was signed. It's a memorandum from him to the board of the fire district, where he says, my annual performance review, well, he speaks in the third person, he says the annual performance review of the fire chief has been completed, and a new agreement has been drafted, and he recommends to the board the approval of his own personal contract. Again, there's nothing to indicate from their records that any of this was done publicly as required under the law. That was followed a few months later with negotiations, again behind closed doors, of a second amendment to his employment agreement. At this time, as we've indicated in the memorandum, it was clear to Chief Nowicki and to the district that he had been planning his retirement during this period of time and that his retirement would be imminent. His annual base salary remained the same. Now his vacation leave was increased to 28 hours a month from 20 hours a month. And he was granted retroactively the right to sell back 260 hours, and that was retroactive to July 1. So again, all those hours that had been accrued but may not have been cashable during the time that he was working and earning those hours suddenly retroactively became cashable under the Second Amendment to the contract. His administrative leave, which previously was not cashable at all, under this Second Amendment was converted or convertible to vacation leave and made cashable for the first time, again retroactive to July 1 of 2008. He received increased paid holidays as well, floating holidays, again retroactive to January 1 of 2008. That's a 12-month retroactive period. And as soon as this agreement, this amendment was inked with the district, that December, right before his retirement, he sold back 60 hours. Remember, he had previously sold back under the first agreement 200 hours that he hadn't previously had the right to do. So this was now 200 plus 60 in December, and that became the sale in 2008. And then as soon as January came, 2009, a new calendar year, he sold back another 260 hours and then retired, causing both of those 260-hour sales, which were not available to him at all under his contract, to become pensionable, giving him a cash out within the final year of 560 hours worth of vacation time. At the time thereafter, when this first came to light, one of the directors, Pete Wilson from the district, stated publicly that the board members deliberately made the changes to help Nowicki increase his pension, and that the chief presented them with calculations documenting the effect. This is the article that appears in tab 15 of the materials. So it was quite clear that Chief Nowicki at the time engineered this treatment with the district and with the district's knowing participation. According to at least one of their directors, the article says, according to 3 directors, they knew when they approved the contract amendment that Chief Nowicki was planning to retire. So these additions were not recognition or incentive to continue to serve as the fire chief. In fact, everyone knew that he was going out the door very shortly, and these additional benefits were granted retroactively for the purpose of spiking his retirement allowance. If you go to tab 12, there's a letter from Fred Weil, the president of the Moraga Orinda Fire District, in July of '08, that refers to the fact that the board, the fire district board, met, as he says, several times in closed session to evaluate the terms and conditions of your agreement. This is in '08 and '09. There is no indication that any of this discussion about additional compensation or the retroactive compensation ever took place in public, as we believe is required by the law. All of these discussions appear to have been involving not a negotiator negotiating with Chief Nowicki and then coming back and reporting to the board and getting direction, but the entire board behind closed doors negotiating the terms of amendments in the year, knowingly in the year of retirement, admittedly for the purpose of increasing the retirement allowance. Again, if you look at tab 17, as happened with the previous amendment, the fire chief writes a memorandum to the board of the fire district in November of 2008 and says, as you know, we've been meeting, working cooperatively to negotiate adjustments in my contract, and I hereby, as fire chief, recommend to you that you adopt my contract. Three days after the Second Amendment was inked, Chief Nowicki sends an email, this is tab 16, to his colleagues, firefighters, rank and file, telling them that it no longer makes any sense for me to remain as the fire chief. I should retire because I can make as much money in retirement as I'm making now, in fact more. But don't worry, because at the same time we've been negotiating our contract, my contract amendment with retroactive increases for my pension, I've been negotiating a contract to come back immediately after retirement and do the same thing I've been doing previously. And so he says, this is again December of '08. December 10th was the signed Second Amendment. He tells everyone at the fire district, we've been entertaining discussions on my continued service as a contract employee. And then if that happens, this will all just be a paper transaction. And in fact, that is exactly what happened. He retired that month, the following month, January, and came back on a contract doing the same thing he'd been doing previously. But now he had a pension of $240,000 or more. So, let's go back to the issues for you and the standards for you to consider. 31539 says that you may consider that if the member improperly increased his benefits at the time of retirement, that is an error and that you may make adjustments. That section does not tell us what improper means. As I say, it does not give us a bright chalk line. Remember, the rest of the 37 Act, all the things that we've talked about for years now, have to do with the word determine. Compensation earnable on which pensions are based on what the board determines is the average annual compensation paid to an individual of the same grade or class for regular work. It's that word determine. Same word appears in other parts of the law. The same ideas in the Constitution on your fiduciary responsibilities. It's up to you to determine, in this instance, what is proper and improper. The legislature has repeatedly given this board and boards like it that responsibility from the diverse backgrounds that you bring to this board to make a determination under all the evidence presented to you as to whether, in this instance, this benefit calculation was proper or improper. It's a judgment call, and the courts will support you. Unless your decision is completely arbitrary and capricious, if it's reasonable determination, the courts will support your exercise of discretion in determining the propriety of these benefits. What I can tell you is this: the section that we're talking about, the authority that's been granted to you specifically in this situation, was put in the books in 2004, and it was a reaction of the legislature to a situation that came up in San Bernardino County under that system, the 37 Act system in San Bernardino, where there was collaboration between county officials and some employees, members of San Bernardino retirement system, to increase their pensions at the end of their careers. And this law was put on the books specifically to give you the authority to take that situation and to say, that doesn't smell right. And this is your opportunity to consider that in this situation. The elements that have to be shown, I believe, are that the member participated, the member caused. This can't be a passive error in reporting by the employer of compensation. Those are other error type corrections. This isn't a situation where the system made an error in calculating a benefit. This is meant for a situation where the member actively caused an increase that was improper. And then there has to be an improper increase or an overstatement of that person's final compensation, and again, done at the time of retirement. Based upon our evaluation and all the facts made available to us, and I will readily say that I don't know that we have all the facts available to us. The materials that we received from the district were spotty in many instances. We had situations where some minutes were not complete. We had other things where they simply weren't responsive. They claimed that they didn't keep the records, that sort of thing. We've not subpoenaed records from anyone. We've not subpoenaed records from Mr. Nowicki. But the purpose of this proceeding today is to provide that opportunity, that if the member or others have information that's relevant to your making a determination, this is the time and place for them to bring that forward. All I can tell you is that based upon what we consider to be a thorough evaluation, not a complete investigation, but a thorough evaluation of the records of Cicera and the records that were made available to us from the district and that were in the public record based on media reports at the time, that we believe that the elements of an improper increase are here. There's no question that this member participated actively, in fact designed, if not engineered, or whatever other active verb you want to use, was the instigator of the increases, the retroactive increases that were granted, knowing that he was within a year of retirement. We think the indices are here that it was improper. It was granted retroactively for work that was already performed under his existing contract. He didn't have the right to cash these things out previously. It was negotiated in secret. Now, maybe someone will pick with me about the word secret. What I mean by secret is there is a strong public policy in the state of California that compensation of public officials shall be discussed and disclosed publicly so that the citizens and the taxpayers who pay those salaries have an opportunity to participate in it. Those of you who are elected public officials know this quite well. It's read throughout the government code and other sections of the law. The Brown Act, that discussions about evaluating someone's performance may be done in closed session for obvious reasons, but when it comes time to compensation, those discussions need to be made public and conducted in public. And the fix can't be in behind closed doors and then simply announced in a public board meeting. It certainly doesn't go on at the Board of Supervisors or any other public elected board. So we believe that the evidence is extremely strong here, that all of these discussions about the chief's compensation and the retroactive aspects of it and the increases and the cash outs and increasing his retirement allowance were done behind closed doors with the entire district board, not with a labor negotiator, and never brought out publicly until it became a done deal.
Mr. Leiderman, can I ask you a question?
Question.
Just for the sake of our record, because I want to be clear on this, your report is dated August 5, I believe, is that correct?
Correct.
And that was provided to Mr. Nowicki?
I think it might be before August 5. That may be the date of it, yeah.
All right.
Yes.
So you have requested from the Moraga Orinda Fire District records, which would include minutes, formal agenda postings, staff reports, recommendations, analyses, and so forth. We've made that formal request. You have done that?
Yes, we initiated a public records request of the district.
And we've received some records in response to that?
Yes, we have. And I believe, Karen can correct me, I believe those records have been made available to Mr. Nowicki. I'm not sure. But he had equal access to them as we did. But we used a public records request for that purpose.
And you've also contacted district council, the MOFD district legal counsel as
Correct.
well?
They're outside legal counsel.
And requested records, documents, anything relevant to this proceeding?
That is correct.
And did they provide you with anything?
Just as part of that PRA response.
All right, thanks.
I have a question. You alluded to the fact that you thought there may be some information that was not complete and not available to you. Do you know that to be?
No, I can only surmise. I don't know what I don't know, put it that way.
Yeah, okay.
No, I simply don't know with the universe of material may have been out there, may have been destroyed, may never have been out there. I can't know. I can only go on what we have. What we have, however, is consistent with what we put in the report, obviously, and we've given you the key documentation that supports it. Now, this was all clearly done at retirement. Chief Nowicki knew he was going to retire imminently when these deals were cut with the board. They were all signed up within the final compensation year. It's also apparent from his his email to his colleagues that he knew he wasn't even really retiring. He was just cashing in on his retirement allowance at the time. Now, it is also true that during this period of time, he was communicating with a staffer here at Cicera, trying to figure out how much was going to count and how much wasn't going to count in his benefit. And so it is true, we know from the records that we have made available to Mr. Nowicki and that we've reviewed here at Cicera, that there was at least one staffer doing calculations, pre-retirement calculations with him based upon these amendments in the contracts. Those, of course, are not binding on the board. The board never took action about that, and the board didn't have knowledge. And it's pretty clear that it doesn't matter in terms of whether or not a correction can be made or not, that someone at the retirement system at the staff level had knowledge that all this may have been going on. How deep that knowledge was, I have no idea.
And to that, do the records indicate that there were any recommendations from our Cicera staff, usually with A, B, and C, in order to enhance it? Again, recognizing that's irrelevant from the standpoint of even if we did make an error, our staff made an error, we nevertheless have knowledge requests.
From the written material that we have, there's no indication of that. Don't know what oral statements could have been made or remembered now, but we have nothing in writing that says, here's how you can go about doing this,
Okay.
from someone at Cicera.
Do you have the first date that he made contact with our retirement system?
No, and the reason is this, from time to time, at least from our records here at Cicera, it appears that, like many members, he would inquire, I think back in 2005,
I did mine several
2006, I mean, he would inquire about what goes in, what doesn't go in, what's counting, that sort of thing. Here's an example, if you can read it, I'll read it. This to me confirms what we've been saying about the state of mind and what the whole purpose of these increases were. This is the fire chief writing November 25th. This is before the Second Amendment was signed by the district, before it was approved officially anyway by the district board. He's writing to Marge. Marge was a staffer here at Cicera. And he's saying to Marge, here's the final agreed upon changes to my MOU, and the attachment was the Second Amendment to his contract, with noted effective and retro dates. It will be approved and signed by the Board of Directors on December 10th. It certainly wasn't going to be approved for discussion on December 10th. I thought you'd like an advanced copy so you can run the numbers. And send me a copy of the final tally so I can double check them. I'll be retiring on January 30th. I'll make an appointment with you sometime in December. This captures what was going on, I believe. And basically saying, okay, I got this all lined up, the district's already approved, it's gonna get, in my words here, rubber stamped by the board, by that district board on December 10th, but it's a done deal. And I'm doing it, I know I'm retiring, before the contract is inked. I'm telling you I'm retiring. And I want you to run the numbers for me. There are some previous communications that we have back in September, October, where he's clearly contemplating the double sale back of vacation cash outs before they were ever approved by the district. Now, I said earlier there were a couple of changes. Since the time we wrote the memorandum, we've done some further investigation, we've done some further review. Out of fairness, there's some pluses and minuses to our calculation that I want to bring to your attention. There are three of them. Base salary. In the memorandum, we talked about the increase in base salary, and we focused on the 6 months that it was made retroactive. But the fact is the base salary increase was effective for all 12 months in the final comp period. The retro period was not in the final comp period, but then the next 12 months were. So instead of, in our memorandum, we included 6 months of base salary increase, should have been 12 months. So instead of $6,500, it should be $13,000. The fire retirement allotment. In our memorandum, we said that should be backed out. We've taken another look at it. It now appears that, let me tell you what this is. This is essentially a way of doing an employee pickup contribution without making it pick up for tax purposes. Essentially, instead of the employer, say the employee's contribution, the employee contribution to the system is 5%, let's say. A long time ago it was 5%. If the employer picks up, as happened with a lot of safety members over the years, if the employer picks up that contribution and makes that contribution, that's never been treated as pensionable compensation. But this is a hybrid of that this system always treated as pensionable. the FRA, Fire Retirement Allotment, essentially grossed up to the member additional pay for the purpose of then having them be able to pay their own contributions into the system. So they pay their own contributions into the system, it doesn't get deducted from their pensionable compensation. Plus, Cicera gives them pensionable the amount of that allotment, that grossed up allotment. So the fact of them, there are two reasons why, since our memorandum, we believe that that should not be deducted from Chief Nowicki's final compensation. One, because it was done this way for everybody in the system who got this allotment. But more importantly, it was in his original contract. He had an FRA in his original contract before these two amendments came down in his final comp period. So from our point of view, that fire retirement allotment is permissible under our policies that we had at the time and may be included in his pensionable compensation. And the final thing that we didn't focus on, and thanks to Kurt for pointing this out, because of all these cash outs, remember, we not only counted for legacy members, we not only counted a year's worth of cash out that they had during service, sometimes two because of the straddling, but then another year's worth of cash out in terminal pay. Well, because of this manipulation that took place in these two amendments to the contract, he got 336 hours also included in terminal pay, when the most he should have received was 240. So we would back out the difference between 336 and 240, the value of those hours. Those are the three changes to our memorandum, and I'll summarize them here. The retroactive base salary increase is $13,000. The floating holiday payout that was granted retroactively, $9,600. 200 hours that of new sellable vacation that was done in the final comp year, $18,606. The December vacation sellback of 60 hours for $5,500, 24,000 worth of vacation sellback in January at retirement, and then the adjustment to terminal pay, backing out from the 336 hours down to 240 that he would have gotten in terminal pay, even though it wasn't cashable. Labor code says you got to pay people in cash their accrued vacation when they retire, and he would have gotten 240 hours at retirement. The total adjustments that we are recommending to his initial pension is $80,200. So here's the calculation. We believe that his pensionable compensation was overstated by $80,200 because his formula would give him 85% of his compensation as pensionable. The adjustment to his pension, we believe, should be $68,000. That was his initial pension. So his initial pension, annual, was $240,923. We believe that $68,000 needs to be backed out of that, and that his correct initial retirement allowance should be $172,818. On that basis, the overpayments that were made to Mr. Nowicki and his former spouse from 2009 through this month, with the COLA adjustments that have accrued, is $483,310. If that is recovered with interest, as the IRS requires and as provided in your policy, the total overpayments to be recovered with interest are $617,458. And just for point of information, making the correction forward from the October 1 retirement check going forward on an actuarial basis, present value basis, the cost difference to this system and the employer is $1,289,331. We are recommending to you today that you determine that these increases under the circumstances presented to you were improper under the statutory definition, that you take action under your policy to recover all past overpayments with interest, that you adjust the future benefits accordingly, starting October 1, 2015, and that if that is your determination, that we advise the member and his former spouse that this shall have constituted an exhaustion of their administrative remedies. They don't need to file additional claims or something against the system. If they wish to contest, as any of your decisions are contestable in a court of law, they may proceed to court if that is their desire. That's the total of my presentation this morning to you. Happy to answer any questions. Certainly, as I see on the agenda, we want to entertain comments from the member, former spouse, members of the public. As I said, I was advised by the district's counsel that they do not wish to appear and present anything to the board on this subject, so we will not be hearing from the district. Thank you, Mr. Chairman.
Thank you. Any trustee questions?
Harvey, you were saying about not having all the information that you don't think you got parts of it from the district. You think subpoenaing any more information would give you any more information to change your opinion?
Well, I have to take the district and their counsel at their honor, that when we do a formal public records request, and they know what the law is under the PRA, that they have used their best efforts to comply with the public records request, as they would with anyone making a request. They also have an obligation as a participating district in this system to report to us accurate information. There are consequences if they don't. We've been given additional audit powers under the relatively new law that came in with PEPRA. But I can, if you're asking me, would a subpoena delivered by a gendarme such as yourself get more attention or maybe unearth more documents? I can't say that it would, and I don't think so. I have to take them at their word that they've complied with the law in our public records request. It would not be. It was comprehensive enough to cover everything.